Welcome to something I like to call Legal Lessons with Haley. Here, I describe legal topics so that they're more accessible to the general public. As a preface, this is not legal advice and I am not your lawyer. Also, I live and practice in Ohio, so you might want to check your state laws because they might be different. Today, we're going to talk about burdens of proof. So basically, a burden of proof is how sure you have to be that you're right before the law says, okay, you win. So criminal cases obviously have the highest burden of proof, which is beyond a reasonable doubt. So the government has to prove that the defendant is guilty beyond a reasonable doubt, which basically means that a reasonable person would have no serious doubt that that person is guilty. Basically, you have to be almost certain. Civil cases use preponderance of the evidence, which is a 51 to 49. So you don't have to be completely sure. You just have to be more sure than not. The last standard is called clear and convincing evidence. And that standard is only used in special circumstances like terminating parental rights, fraud cases, or trying to prove that somebody lacked capacity to make a will. The standard is more likely than not, but highly and substantially more likely to be true than not. So instead of just tipping the scale on like a 51% for clear, true and preponderance of the evidence, it's more like 60-40, 70-30, 80-20. It's like higher up on the scale than just 51-49. And those are the three most common. There are other burdens or other standards that are used when you're doing an appeal and doing like constitutional cases that I'm not going to get into, but hope that helps.